Good afternoon, ladies and gentlemen. Sorry for the slight confusion. We found that the names on the nameplates were wrong in some cases. Okay. Come in, everyone. Come in. I think I should wait for a few minutes. I'm glad to see so many people here. You probably noticed that the listing of the title and the speakers in the program is not quite what you see here. Don't worry about that. We have made constant improvements, as they say. So the title of this workshop is now The Right to be Forgotten. I put it in quotation marks because it's a phrase which is evolving, and privacy and anonymity and access to information. These are all hot topics in the legal space, in the information community, in the internet, and in constant subjects of discussion among countries in the region. And this workshop started out as a stream of 4 workshops which got pushed together. So we have been dealing with an interesting question of how you combine different perspectives on all of these subjects which are all related but which are different. And in the end we concluded that we should not try to aim for a complete satisfying synthesis of all of these things. Well, if we can find that, that would be good, but I don't think we need to try. What we need to do is simply have an interesting discussion about these questions. And the people you have here, whose names I've listed on the screen, are KS Park from OpenNet Korea, Monica Zanyaruch from Australia, from other places too, but Australia at the moment. Yasuyo Inouye from Japan, who's a colleague of mine working for IFLA, and Smita Vaniya from Point of View in India, Nikhat Dad from Digital Rights in Pakistan, Jamail Jacob, we call him Jam, is that right? We call you Jam? Are we allowed to? All right. From the Foundation for Media Alternatives, and I'm not sure if the last speaker is in the room. If Sarvjit Singh is in the room, could he please raise his hand? No? All right, well, maybe we've lost him. Never mind, this is the constant story of this workshop. We lose people all the time, but that's freedom of expression. Okay, now, what I want to do, first of all, is give the microphone to each of these speakers in turn, starting with KS, and ask each person to say a couple of words about the organization that he or she works for, and then give some perspectives on the right to be forgotten, privacy, anonymity, and access to information in cyberspace. Come in, and then maybe explain some of the legal perspectives on these issues in his country or her country. And after 2 speakers, I'll stop and I'll just ask you if there are any questions from the audience. Then we'll go on to the next 2 speakers. So I don't want to hit you with all of the speakers, all in a block, and then come back to questions right at the end. I'll do that. I'll do some questions at the end, of course, but I'll try to intersperse time for questions between the speakers. Okay, first of all, KS, would you like to give us your reading of the situation with these hot topics and introduce yourself first.
Yes, my name is Kyung-Shin Park, but you can call me KS. I'm a law professor at Korea University. I also lead a nonprofit organization called the OpenNet Korea that has worked for a free and open internet. Right to be forgotten is a, well, it can have different definitions, but it can be defined as one's ability, one's legal capacity to suppress or sanitize search results about him, which contain true and public information about that person. Now, defined as such, the problem with the recent wave of right to be forgotten is that it is based on the concept of data ownership, not based on any widely accepted notion of privacy. So, according to that concept, one owns data about himself or herself, regardless whether that data is public or private. So, right to be forgotten ends up protecting public facts about that person. That I did not pay someone wages 3 years ago. No one would consider that private, yet, according to right to be forgotten, I own that data, so I can ask Google to suppress people's access to that information. That I did not pay taxes a few years ago, which led to enforcement on my house. I own that data, I can suppress people from searching for it. That's how right to be forgotten operates. But this is the question. Do you really own data about you? Consider this statement. Actually, PowerPoint should have, yeah. There we go. All right. That's me. That's my Twitter handle too, so you can follow me. You should just go to the, yeah, yes, that's good. Now, consider a statement. Consider a statement, John, the husband, beat up Jane, the wife. That's also data. Now, John regrets and is embarrassed about it and wants to keep it low. But Jane is still mad about it and wants to make it a lesson for John and the likes, so wants to publicize it. Who owns that data? Who owns the data about that wife beating, and who should have a control whether that fact of wife beating is shared with others through Google search or other platforms? There's really no answer to that. So as we can see, the concept of data ownership, which usually underlies any good right to be forgotten conversation, turns out to be a mistake. Next. So one attempted justification is relevance. The story goes like this. Okay, we cannot own data about ourselves, but we can suppress people's sharing of data about us that are, quote, no longer relevant, unquote. So the slogan of right to be forgotten goes like, people don't have to know about everything about others, or about, or people don't have to know about everything about one another. But relevant to whom? Relevant from whose perspective? John, who has beaten Jane 10 years ago, may find it irrelevant, find his past relevant because now John is a completely remade person living a model citizen's life. But Jane may find that happening 10 years ago still relevant to teach a lesson for him and many others. Also, third party, like activists, may find it relevant that a former wife beater has turned out to remake himself and turned out to be good, to give people hope that harmful habits can be broken. But right to be forgotten justifies cloaking of this very relevant information or potentially relevant information by measuring relevance from only one perspective, the perspective of the data subject. So in this case, the perspective of John. Next. So some people say that the milestone of relevance is public interest. In other words, the postings that are imbued with the public interest will not be suppressed from search results because the public has interested in it and therefore is relevant. But let's think about public interest. It is what public wants and takes interest. But people are diverse. Some people are interested in, I don't know, right now Pokemon Go, while others are interested in killing sprees unleashed by ISIS. Whose interest represents the public interest? In the end, public interest can be defined only to be a majoritarian or averagitarian, if you will, averagitarian concept which is decided by a collectivity, not by an individual. That's fine, but it goes against the ideal of freedom of speech, which is a pluralism, which says individuals should be allowed to speak their minds as long as they do not harm others, even if what they say may seem offensive to others, or may seem totally out of the whack for others, or may sound radical to others. As long as those things do not pose a clear and present danger of injury to others, like hate speech would do, individuals should be allowed to speak their minds, access whatever they want to access, and share what they know, despite what the majority people consider sound, desirable, or for public interest. Next. Now, a lot of impetus for right to be forgotten comes from a desire not to discriminate people for their past mistakes. The idea is to prevent discrimination by shutting down the information about people. Right? Prevent discrimination by shutting down the information about people. Let's consider that. So, yes, if you don't know that I'm a tax evader, you cannot discriminate me for tax evasion when you do your business dealings, when you choose your next business partner. And if you cannot search for postings about my bad services to my clients, you cannot discriminate against me for being a bad lawyer when you're looking for your next lawyer. If you don't know that I was a child sex offender, you cannot discriminate against me when I'm applying for kindergarten jobs. Is this really a proportionate way of fighting discrimination? Is this true? Is this a true way of fighting discrimination? Yes, one convenient way of prohibiting discrimination against LGBT will be banning people from talking about other people's sexual orientations, period. Or suppress Google searches about sexual identities. But is that a true way to build tolerance? Isn't the world better if people know people's diverse sexual orientations and yet embrace them? Isn't that a true way to fight discrimination? Yes, I agree that expunging credit records or criminal records is important for rehabilitating people. And the state has a legitimate interest in promoting rehabilitation by expunging those records. But that's not right to be forgotten. Now, editing the official records is different from prohibiting private people from sharing what they know about others. It's one thing to expunge the official credit records of that Spanish lawyer in Google Spain, but it's completely another to ban people from talking about the fact that he has gone through house auction. And think about it. What's the real source of evil discrimination? Not discrimination for people's past conduct, but discrimination for obvious traits like race, gender, religion, the things that you don't need to do Google search to find out. Now, so right to be forgotten does not help fighting discrimination in that regard. Now, if you suppress Google searches, I mean, another evil from right to be forgotten is that if you suppress Google searches about people's weaknesses, will live and will continue to live under a misperception that all of us are good, people don't have weaknesses, or at least less weaknesses than there actually are. And that makes it more dangerous because now there's a dearth of information about people's weaknesses. So if any one weakness is exposed by mistake or by some third party, even if it has been kept confidential by the data subject, people will jump on it because there's really no other weakness of others that they can turn to. So right to be forgotten ends up fueling bigotry. Now, the latter presenters will talk about anonymity, and I'm going to try to put anonymity into context here. I think anonymity is what we really need to fight discrimination. Let's next. To fight discrimination, many people go online. Yes, almost done. Many people go online, as they should, to fight discrimination, but by remaining anonymous, people can keep themselves safe from government censorship or keep themselves from the attacks of the trolls. Now, to keep anonymity, there has to be a strict regulation on how the government or third party can access your identity data, and the laws about anonymity are very weak, and I'm very concerned about that because anonymity is a privacy about identity data. So there's no reason to give any less protection than privacy on the content of communication, because as long as it has been kept confidential, it should be protected. So I'm out of time, so I'm going to talk about the Korean experience on promoting anonymity. But to conclude, I want to say that if what we really want is to fight discrimination, what we really need is privacy about identity, not right to be forgotten. Thank you.
Thank you, KS. Yeah, thank you for that. I think if you had other points, then maybe when people ask you questions, you can bring them forward later. The next speaker is Monica Zalarucci from Australia, who is a lawyer, but I'm going to ask her to introduce herself very briefly in 2 or 3 words, and then discuss some of the same issues from a different perspective.
Thank you very much for having me on this panel. So I'm Monica Zalarucci. I'm from University of Melbourne. I've been working on these issues, and especially data protection and privacy, for a little while. And I guess without further ado, once we find my slides, I just would like to start, I guess, for a heated debate. If anything, individuals really do not own their data. So just to continue what has been started, I think that had we owned our data, we perhaps would be very rich, each one of us, and not the giant tech internet platforms, monetizing that data to an unlimited extent, and avoiding any responsibility or costs associated with taking that responsibility that comes with it. Thank you very much. So perhaps what I would like to make a contribution to this panel by looking at the similar issues and similar implications just from a slightly different perspective. And even though I'm a lawyer, I think I would like to look at it from the critical political economy perspective. And the basic premise of my contribution is that, in fact, to an increasing extent, the management of our fundamental rights, including privacy and as a subset, the famous or infamous right to be forgotten, is increasingly managed and mediated online by private actors. And these private actors, including the internet content intermediaries such as Google and Facebook and YouTube and Instagram and various others, as well as also various global internet governance institutions such as, for example, ICANN, do in fact govern and manage and mediate human rights online via their standard contractual clauses and internet architecture, such as domain name system, algorithms, online content moderation by these algorithms, and so on. And these contracts that feature standard terms and conditions of services, be they with Facebook or Google, or be they for your domain name, they often present such an illusion of choice for the users or domain name registrants. They must either agree to those services, or they will not be able to use the service, or for example, if they upload the content that is against those terms and conditions, it will be removed faster than you notice. And so this phenomenon, which I would like to talk and discuss further with the panelists and the audience, is increasingly described as privatization of human rights. And famous scholars such as Laura Denardis, for example, has talked about these things. And so the idea is that the private actors, instead of public policymakers and the public, do establish these boundaries on online rights to expression and privacy in accordance with their business models that might be useful for them. And so whereas in the past maybe the governments were more involved into policy making in the digital environment, it is mainly these private actors do those things. And I would like to draw attention to several examples maybe that would make this more obvious. So for example, the global free speech standard is in fact set by Facebook, for example, as it relates to the public nudity. That's why you cannot see a female breast on Facebook, or let me be more precise, nipple. And maybe, whereas you can see a male breast and nipple without any restrictions. So maybe you have noticed this very, I would say, very clever and wise breast cancer video campaign on Facebook, where it was actually a male breast used to talk about female breast cancer, just because it is allowed. And so none of us actually made this decision, and it was never debated in any forum that female, for example, breast is against some sort of public morality. But nonetheless, it is a de facto global standard, which is there. In a similar way, but perhaps with a more complexity involved, Google and versus Spain case, the famous right to be forgotten case, could be interpreted as explicitly giving the mandate to Google to be, in fact, the global watchdog for individual privacy and the right to be forgotten, because the delicate balancing act, what my colleague has just talked about, who decides whose interests are to take priority, is actually left in the hands of the private actors to make this delicate balance between the competing values of public access to information and individual right to privacy. And so these decisions on what is permissible and what is not are made internally behind closed doors, very often by subcontracted companies, by these internet platforms, and the guidelines and criteria for such decisions, for example, indeed, how Google decided which links should be removed or which ones should stay, the criteria is not known to us, and we cannot put any pressure, be that legal or just public pressure. We don't have these tools of accountability and governance. And I think this leaves the private actors, those internet platforms, with the most power. And in this situation, we are actually caught, we're caught in this, very strangely, I do not find my, okay, here, in a feedback loop where we're actually certain interests do align, and to break this loop, it becomes very difficult for individuals, for activists, for the civil society, because policymakers and the governments are actually quite satisfied with the current situation. And that's why they delegate a lot of these mediation and moderation of fundamental rights online to these private actors, because then they can actually demand the data that they have of these private actors, very often as well behind closed doors. So as long as the governments keep demanding access to the personal data and actually refrain from legislating any protections, it is easier to keep the system flowing, and it's a powerful feedback loop. The business model supports the government effort and vice versa. The government effort justifies the business model. And the current situation, where the interests of two powerful actors align, states and multinational corporations, in fact is very dangerous for fundamental rights and individual rights and democracy. And what I want to now connect perhaps more with the decisions on right to be forgotten and how they could be understood in this kind of context is that regulatory intervention is very difficult and unlikely. And judiciary is pretty much, especially the EU Court of Justice, I would say, is trying to push back against this regime, because political actors do not see it perhaps this way, or as I just described, perhaps their interests do align with such models. And I would say that recent invalidation of data retention directive, or Schrems decision, or Google and Spain decision, just show that in fact judiciary is finally adopting a different approach, which is in stark contrast with the lack of leadership shown by political actors and states. And we can discuss all of this with the fellow panelists and the audience. I just would like to say that in this context, without going into small legal details, I would just like to say that Google and Spain decision, for example, the right to be forgotten decision, could be understood in this context as a pushback against the continuous expansion of limitless monetization of personal data by Google and by other corporate actors, without trying to, without taking any responsibility or trying to avoid most of it. So, whereas I would say the Court of Justice tried to impose this responsibility because actually that's the Google profiting of this data, it turned out to be very paradoxical consequences of this decision, because as I mentioned earlier, I think it gave Google the right of the actual de facto watchdog of privacy rights, balancing the delicate interests. And I leave my contribution here, and I would like to discuss this with fellow colleagues and the audience later on. Thank you very much.
Okay, can you have the next PowerPoint by Inuye? Thank you very much, Monica. At this point, would it be useful, I think, I wonder, to note any questions that you might want to discuss later? Because those are two very complex presentations of very fast evolving legal situations and debates, and listening to them, all sorts of questions may have occurred to you that you might not remember later. So if anyone has any questions now that we should note down for discussion at the end, could you tell us? Yes.
Okay, one thing to add about private making company using the data. Sometimes it's just very convenient. Sometimes people do not know how the data being used, what service is powered on. So something to take note is it's actually a bit more complicated than that, because it's convenient. Something it's just easy to just give. Okay, that's my opinion. Thanks.
Okay. Maybe you can answer that quickly.
I don't think it was even a question. It was just a very good remark. And indeed, one of the points that I wanted to make maybe implicitly is the convenience of the current model for the government. That's why for us it is difficult to demand any change. And even if the change is proposed, let's say by the judiciary, I would say that the fate of the invalidated data retention or the Schrems or even the Google Spain is very uncertain if anything is going to change, because simply the convenience is a very high factor, I think.
Thank you. Any other quick comments and questions? I saw one other hand up before. No? Okay. In that case, can we move on to the third presentation by Yasuyo Inuye? And Yasuyo, could you introduce yourself briefly and then discuss the issues?
Okay, my name is Yasuyo Inoue. I'm from Japan. I'm professor at Tokyo University to teach on library science. Are there any librarians here in this room? Librarians? No librarians. Okay, I should explain about what the librarians do. We select books, materials, informations, collect books, provide books, discard or preserve books. Why? Because we have to provide the people's memory to our great-great-great-grandsons and daughters. That's the history. We are making history. So right now, I'm a member of the IFLA, the International Federation of Library Associations and Institutions. That kind of international organization of all over the world librarians get together. And among that IFLA, there are the 5A, that's a Committee on Freedom of Access to Information and Freedom of Expression. So we librarians also think about that freedom of access to information and the freedom of expressions. Because libraries or librarians, we have the mission, as I said, we have to provide information to the public. And we have to do free access to information, freedom of expression, and preserve the adequate, or everyone wanted to have the enough reading environment. So why? Because people want to know. But as KS mentioned, that it's very risky borderline because people wanted to know everything. But we have to think about what is most important things. So we make the statement on libraries and intellectual freedom. So we just don't follow what policymakers said. So we want to follow our mission, what librarians should do. And also, we have the statement on the right to be forgotten, because, as I said, we preserve, not all, but we preserve books, materials, informations to next generation, to next generations, 4 and 4. So that's historical records. Sometimes someone don't want it to be read by the others, but someone wanted to read or get information, especially historians need such kind of the record. But we have to, it's very difficult. We have to divide what is the private person's privacy and public person's information. As Monica mentioned, that policymakers very happy to hide what they are doing behind their closing doors. But that is what people wanted to know, actually. So we have to think about that. Maybe private persons wanted to do the RTBF mentioning, but policymakers, do they have the right to do so or not? I think in society, the people have the right to know. So librarians or libraries to support people's right to know. And also, we have the statement on privacy in the library environment. It is not only RTBF, but also sometimes the authorities, maybe with political power, come over to the library to ask who is reading this kind of book, something like that. In Japan, we have the very bad memory. During World War II, some special police came over to public library and checked who circulated this kind of books. And after that, they arrested these people, something like that. So that is a very bad memory. So not only we Japanese ones, but also I think all over the world think about that, protect the privacy, who is reading what kind of books. So that is very important, the privacy information. And also, as I said, that the historical memory, if we preserve the historical record, but not like just a kind of scandalous information, but also historians wanted to know the information when do research. So we protect that kind of accessible, historians accessible activities. But most important thing that we say that the statement on right to be forgotten, we found that, as Monica said, that the Google and the Spanish people, the person in Spain, Google ordered to not to be searched, but the original record at the newspaper article database, they are not derated. So librarians try to do our own technique if they really wanted to know that policymakers' information, we try to find for you, something like that. So the IFLA try to ask librarians all over the world, try to help the people who really wanted to get information to make the society or community transparent. So try to help those people, not like support the peeping toms or something like that. So that is the meaning of the statement. But most important thing that it's very risky right now who decide why, how, who control the information. In my country, in Japan, there are more than 600 claims using that RTBF reason. Only 3, the court, local court, ordered not to be searched this information. But there's no activities to make up to legal role. I don't know the next year, but right now the court try to judge whether that is a public one or private one or so and so. So the other countries, sometimes everything shut down or something like that. So that is very risky situation. So at the time of the RTBF discussion, we think about it, who decide, why, how. That is most important discussion point. That's all. Thank you.
Thank you, Yasuyo. Can you give me the second slide on my presentation now? The second page. Okay, that's fine. Before I talk about that, well, that's just really a shopping list of issues which I thought might be useful at this point. I would like to make some comments to support what Yasuyo has said, speaking for the library information sector, because we're not talking here about the sort of libraries where you take your kids on Saturday afternoon for someone to read them stories. We're not talking about libraries and schools providing education resources, although those are very important as well. What we're talking about are state-run libraries or high-level academic research institutions which have a function to support policy making for information strategies in countries. And Yasuyo is a teacher of information science, and she knows that too. I work in a national library, the National Library of New Zealand. Although I'm here wearing an NGO hat, I'm also a public servant in New Zealand. And our National Library has a mandate defined by Act of Parliament, which describes our obligations, which include collecting and protecting original documents and making the content of those documents available to the citizens of the country. But in particular, we have to keep those documents in perpetuity. Now, think about that. In perpetuity is quite a long time. Now, if we are going to keep these documents in perpetuity in practice for centuries, then we have to preserve the originals, but we also have to preserve them in conditions whereby the content can be made available to the citizens and the descendants of the descendants of the descendants of the citizens of the country. That's our legal obligation. So to do many of these tasks, we digitize information in our collections as much as possible. And digitization, as you know, means that you can retrieve information much faster, you can drill down much further, you can go back further in time, pull out information which you could never have done before in the analog environment. So you can, in fact, find information from the past quickly, whereas, in fact, in the old days, the practical obstacles to doing that would have been just too great. They would have been a deterrent to doing that research, maybe, or finding that information. So one specific example is that we have digitized all national newspapers from the 19th century, pretty much when New Zealand started as a modern state. We've digitized all newspapers in both our official languages, English and Maori, through the 19th century and up until the first 3 decades of the 20th century, until copyright stopped us from going any further. Now, this database of digitized newspapers, called Papers Past, is a resource for historians, which has brought us great praise from the academic community, because it enables research to be done on keywords, not just by photographing pages from newspapers, but actually drilling down into the actual words, searching on words, names, and places over the past 150 years. Now, this has a great advantage. For example, the Maori people of New Zealand, the indigenous people, wanted the government to compensate them for land that was confiscated in the 19th century. They made a case for doing this because they could find in our digitized newspapers from the middle of the 19th century actual court records and descriptions and news items of Maoris, of indigenous people whose land was confiscated by white settlers, for example. There were actual cases documented, put into the newspapers, and they could search now, 5 years ago, 10 years ago, search on these records and pull out the information, take it to the government and say, this is evidence for compensation. And they won their cases. Now, that is something that was never foreseen in the original law that we according to which we operate. Another thing I should say, speaking for the other side of the street from where I work, that is the National Archives. The mandate of a National Archives is to keep all records of government. And they also are required by government now to digitize all their records so that researchers can pull out information from state records, not only people's publications, private publications, manuscripts and things like that, but you can now pull out from digitized state archives things which were never expected to be revealed. So what I'm trying to say is none of this stuff can be forgotten, because our law tells us we must make it available. So we are in conflict with ourselves. Now, just to say that these are some of the questions which we thought it would be useful to name check. Access to information has been mentioned in this conference already. It was, in fact, the third action line of the World Summit on the Information Society's principles in the Geneva Declaration. That was a statement on the value of access to information for education and science and culture. And since the World Summit ended in 2005, the post-World Summit process has led us through to the Sustainable Development Goals now. We went right past the Millennium Goals because they could not really be fully achieved, and the international community decided to table those, to accept what had been achieved and park the rest, and then move forward to the Sustainable Development Goals for 2030. And goal number 4 brings back, emphasizes again the importance of support for education and skills. It emphasizes the need for equitable access to information and skills and education, and particularly for girls and women, because the emphasis in the Sustainable Development Goals is on equalizing access, overcoming digital divides, and literacy, greater literacy and greater numeracy will help people achieve better employment, give them better life chances. And looking at the third bullet point, sustainable development requires equal access to economic resources, of course. Access to information and access to economic resources often come from interacting with this information in physical spaces. It's not only the internet at home in your lounge, it's also going to a state-funded, community-funded, local-funded institution, such as a school or a library, where people who don't actually have affordable access to the internet or the equipment, where they can actually find the physical facilities to do their work and their learning. And okay, I'll stop there. The next person who needs to talk with us is it Nihat? Jam? Okay. Have you got a microphone?
Yeah. Could I just get the presentation, please? Okay. Good afternoon again, everyone. My name is Jam Jacob. I represent Foundation for Media Alternatives, which is a non-government organization based in the Philippines, working towards the promotion of communication rights, which essentially translates to internet rights these days. Okay, so I see my name is still written as that of my former office mate, which is Nika. Anyway, I'm here to talk about the right to anonymity. This particular right has been a constant issue or topic these days in many forums or fora, such as this one. Particularly, I suppose, because of the heightened premium we give this today to the human right to privacy. And then my agenda and that of my two other colleagues here is to give you or to present a microcosm or a chunk of this larger ongoing debate regarding right to anonymity, highlighting in particular its significance in our respective contexts or jurisdictions, which is the Philippines in my case. Now, as first speaker, I suppose the burden falls upon me to somewhat give a very brief introduction as to what this particular right is all about. So right to anonymity, I think earlier it was a somewhat abbreviated definition already was given, which is that it essentially pertains to privacy over or regarding one's identity. In some other materials or references, the right to anonymity has also, especially in the context of the internet, it has been referred to as that right of an individual to communicate anonymously, which means essentially with no names, or through the use of pseudonyms or assumed names. So that's the right to anonymity. What has been the debate essentially regarding this particular topic has swirled or has revolved around its significance vis-a-vis the trade-offs that we as individuals or as various societies coming from different backgrounds encounter when we deal with this particular right. On the one hand, the right to anonymity has been forwarded as necessary or a vital component in upholding or in promoting other equally fundamental human rights, such as the right to freedom of expression or the right to privacy. For many people, with anonymity, it fosters expression on their part without fear of reprisal, as written there. It also enables whistleblowers and allows people to talk about many sensitive issues that they would otherwise be uncomfortable discussing with other people. As regards privacy, many of us essentially want to try to still create this distance, no matter how artificial that may be, between our online identities and then our offline identities. And the reason behind this could be also belong to a range of possible personal reasons, be they be political, to avoid political economic retribution, harassment, and threats. So essentially, who benefits from right to anonymity? Many people, or classes of people, should I say, whistleblowers, human rights workers, writers, marginalized groups, victims of domestic violence, as well as the organizations who support these people or group of people. Now, as far as legal basis is concerned, when we're talking about the right to anonymity and its related concept of encryption, in the US context, for instance, their Supreme Court has constantly or consistently acknowledged that the right to anonymity is somewhat enshrined or found in their First Amendment, which also contains freedom of speech, freedom of expression. Now, the list I gave here is in the context of the Philippines. So I think for the first four parts there, I refer to sections of our Constitution, the first of which also pertains to freedom of speech, freedom of expression. The next one pertains to privacy of communication. The third one also has reference to our state having this responsibility to provide a policy environment which respects freedom of speech. And then for the last two parts, just examples of statutes or laws wherein our government acknowledges the significance or importance of anonymity insofar as pursuing law enforcement objectives by the government. So, for example, our ombudsman, in going after corrupt government officials, they actually take into account or accept anonymous complaints, as well as our National Privacy Commission, Privacy Commission, which also entertains or accepts similar complaints. Now, moving towards the Philippine context and why I think this is an emerging challenge or an emerging problem in the Philippines. As of now, for those who I guess are following the political developments in our country, we have a new administration led by a new president who, should I say, has been quite controversial in his way to the presidency. Time magazine has referred to him as the Trump of the East, but the Guardian actually did them better by saying he's actually worse than Donald Trump. And and he's so far he's an antagonist. He has been able to antagonize a whole lot of people or institutions, including the United Nations, the Pope, um, and human rights organizations, women's advocates, and so on and so forth. And recently, in his first ever State of Nation address, he actually said that although human rights are important, people should not actually make use of human rights and as excuse actually to destroy the Philippines or the country. How exactly human rights can be used to destroy a particular country, he did not elaborate. So that's one curious fact that we have right now in the Philippines. We also have the fact that currently we have at least two laws that have a significant impact on the right to anonymity. One is our Cybercrime Protection Act, which was perhaps, I think, on record, the most challenged statute in Philippine history. I think there were 15 petitions filed with our Supreme Court challenging the constitutionality of that law. Among its more controversial provisions are its provisions on cyber libel and real-time surveillance. We also have an equally controversial law, which is our Anti-Child Pornography Act. And one of the more questionable parts of this particular law is that it requires actually ISPs or telcos to install monitoring software or platforms supposedly to be able to identify who are actually engaged in or patronizing child pornography. And then, as a consequence of the Supreme Court upholding the provision on cyber libel, there have been a slew of libel cases filed, all sorts of libel cases filed, proceeding or emanating from what we believe at least are erroneous interpretations by our Supreme Court in upholding that particular law. So you have professors filing libel cases against fellow professors, journalists filing libel cases against fellow journalists. As you can see there, supposedly spreading memes during election period could actually be considered libelous. And one actually local celebrity or artist actually, because of one post of one Instagram user, he wanted authorities actually to identify or to be able to identify who that particular Instagram user is in order to file that particular libel case. Still in relation to our current or new president, during the campaign period, his supporters have been the more aggressive, I suppose, types, such that any attempt by an individual to express an unfavorable or contrary opinion as regards their candidate was met by very serious and very offensive threats to life. A woman or a girl was actually bombarded with threats like she should be raped or something to that effect. And then finally, well, not yet. Second to the last slide, we have also two pending bills, which not surprisingly are being supported by our new president, which also potentially will have a large impact on anonymity, which is the proposal to have a national ID system and then a mandatory SIM card registration, which is, I think, a trend that's going on all over the world these days. And finally, we have actually a very sketchy legal regime insofar as our surveillance landscape is concerned. We have a lot of government agencies engaged in communication surveillance, for instance, with the public having very little knowledge actually as to where they get their legal authority to do that. So all these things, all these facts put together, we believe create this very volatile, very dangerous situation wherein the right to anonymity, with all its importance and significance for the many people that I just mentioned earlier, is actually threatened or are already being threatened and will potentially be threatened even more with the passage of these proposals. So I will end there, and I hope to entertain or to answer any of your questions later on. Thank you.
Nikat, okay.
Yes.
Now we have, could you just introduce yourself first?
Sure.
Yeah.
My name is Nikat Dad. I'm from Pakistan and runs Digital Rights Foundation. We are based in Lahore. We mostly do digital rights work in Pakistan, internet freedom, privacy, around the right to privacy and freedom of expression, and do digital security trainings. And when it comes to right to anonymity, I feel that in a country like Pakistan, there is not, it's not being debated yet. We feel that the right to privacy has come into limelight when the government has proposed the cybercrime bill 2 years ago, and there are a number of provisions which actually violates the right to privacy and the right to anonymity. And now the legislature and the senators feel that before such draconian legislation, there should be some protection mechanism in place where, you know, if the people feel that their right to privacy is being violated, that they can get a legal recourse or the legal remedy. So a very little debate has started around the right to privacy, but there is a very recent incident happened in Pakistan, which actually established that why right to anonymity is very well connected to the security of a person. A woman named Kandil Baloch, a very first like social media celebrity in Pakistan, who used social media to share her bold opinion and expression, and I guess she was the first celebrity who actually openly claimed her sexuality and bodily rights on social media. She was a couple of weeks back, she was killed by her brother in the name of honor, and I guess one of the reasons, it wasn't just the murder by the brother, but also a number of reasons which contributed to her murder was that she was using successfully social media because she was anonymous and no one knew about her real name, about her identity, about her address, anything. But somehow when she and when people were taking her as an entertainment and poking fun on her posts, and she was an entertainment figure on social media, but when she seriously challenged the stereotypes in Pakistan, the colorgy in Pakistan, she actually started getting threats, and that's how people were really interested in sort of identifying her real identity. And not only the internet users who used to go to her page and poked fun on her, but the mainstream media played a real role in revealing her identity, not only on the TV channels, but on social media. There is a very famous journalist in Pakistan who actually tweeted her passport on Twitter, and then this tweet was retweeted thousands of times. So I guess it's very important that not only in the online spaces, but how the other stakeholders or the actors violate the privacy of the individuals, and especially in countries like Pakistan where these rights are not established. Although the constitution, the constitutional article 14 says something about privacy of homes, but it isn't interpreted in a very articulated way by the judiciary where it can also apply in the online spaces. So I feel there is a blurry line between the right to anonymity and the security, and this debate mostly in countries like Pakistan, which is a security state, it mostly overcomes by the notion of national security than the civil liberties in the online spaces. So I'm actually interested to hear from other panelists or the audience that how we can strike this balance, and how we can also when when the government comes with a very strong argument of national security in a country where the war on terrorism or the security is a huge, has taken a huge place, how to argue that argument by the government. So yeah, this is from Pakistan.
Hello, I'm Smita. I work with an organization called Point of View in Mumbai, India. Point of View works to amplify the voices of women and remove barriers to free expression. So I will be speaking about the need for right to anonymity, and this in particular, and I'll particularly be placing it with regards to the queer community in India, focusing on queer women. 1 minute, I think this has to come. Yeah, that one. In the pen drive. Oh yeah, my name is there, yes, that one. Yeah. This was a quote. This is a quote from David Kaye's Special Rapporteur report on freedom of expression. Expression and anonymity. Today's leading vehicles for online security provide individuals with means to protect their privacy, empowering them to browse, read, develop, and share opinions and information without interference, and enabling them to exercise the rights to freedom of opinion and expression. And in countries where there is still very much prevalent discrimination and criminalization of sexual minorities and people of alternative gender identities, this is very, very important. This was in a study by Esperanza Miyake. The cyberspace has given the queer woman a chance to problematize the existing gender and sexual identities, which, like any identity, is not static. In India, in the early 1990s, there was the first lesbian organization which was formed. They identified as lesbian explicitly. What they did was they advertised in the only queer magazine which was available in India at that time, and said that any woman who identifies as a lesbian or likes other women, please write to us here, and we will put you in touch with other women in different parts of the country. And a lot of letters came in. What they did was, once they verified the identity of the person to an extent that they didn't need the name, they just wanted to make sure that it was a woman indeed, or identified as a woman, they put that person in touch with women across the country. So without knowing each other's identities, in relative anonymity, people got in touch with each other and formed a community. The internet can enable this today, but you need to have the right to anonymity to do this. If you're forced to give your email ID or your phone number everywhere, or your real name, that's not going to happen anywhere. Creating an online profile like today, portraying your real self is an act of defiance, especially if you're criminalized in your country. Now, this includes creating profiles on dating apps, or joining Facebook groups, or tweeting from your real name, or tweeting what you want to really say. So according to a research which I had actually done for my thesis, a lot of queer people have multiple profiles on Facebook. This is not restricted to just those who identify as trans, but also who identify as gay or lesbian or bisexual. Usually, one profile has their public profile exists, which is on which they are friends with their parents or their immediate acquaintances, etc. And they have another private profile which is unlisted, where they become where they add people from the queer community as friends. Now, this was okay till a few years ago. A few years ago, when the real name policy came up really strongly, a bunch of these profiles were shut down. Facebook would either ask them which profile they would prefer to keep on, but they can't allow two profiles. Some people use the same name on both the profiles, and some people prefer to use different names on the two profiles. The problem with different names is that if you don't have that name on an ID card, on a government authorized ID card, that profile will be taken down. And these were the lucky ones. The unlucky ones were the ones whose profiles were directly deleted. Both the profiles were deleted often. The introduction of the real name policies is actually a major problem for the queer community. The thing is, if you have okay, you say that you are there on Facebook, you join a secret group, which is for the LGBT community in your city or in your country. The problem with this is, once you're in the secret group, your identity is still very open. So if you're very much closeted, or if you really don't want your identity to be known, this is a major problem. Anyone can get into the closed group or the secret group and still blackmail you. Someone who is already there in those groups can still catch and blackmail you. And this has happened in the past. Recently in Tamil Nadu, there were these two women who were together. A family friend saw their photo up on one of these queer groups and outed them to their parents. They were forcibly taken out of college and then separated physically as well. And if the real name policy wasn't a strict thing, if it allowed you to be anonymous, it allowed you to be who you want to be online, this will not be a problem. The issue of the problem with real name policies goes even further. It can compromise directly on the user's ability to express themselves, especially in countries where human rights are being frequently violated, or you are strongly censored for what you want to say. There was a case in India a year or two back where a man was actually burnt alive because he posted a Facebook message against a minister. And if he had an option to do this anonymously, this wouldn't have happened. One second. Next, I would like to speak about sexual expression. Anonymity enables women's free sexual expression without fear of repercussions. We all know that within freedom of expression, there's a huge hierarchy, right? Like, you're allowed to speak up against violence. You are allowed to speak up about your need for education and water and food, etc. And these will all be supported by majority of the people. If most activists would say, yes, you should be allowed to speak about this. But sexual expression does not come under this. If you decide to click nudes and share it with your partner, and it gets leaked for whatever reason, the questions which will be asked to you first will be, why did you click it? Why did you send it out? And such. And this is not from just people who are misogynistic or who are patriarchal. It's also from activists and authorities who are supposed to be liberal. So this hierarchy is there among that. Having the right to anonymity online will strongly enable women's sexual expression. There are a few niche places online which a woman can actually use her sexual agency. If you have right to anonymity, these spaces will be strengthened further. Erotics report of 2011 speculates that queer communities might have been the first ones to actually use the internet to socially network, because it's mainly because of the lack of physical space. And this is not just the case in India. This was the case in a lot of Middle Eastern countries. It was the case in Lebanon. It was the case in Egypt. It was the case in UAE, in India, and I think it's still growing now. Malaysia, everywhere. If you do not give the right to be yourself, if you're not allowed the right to be anonymous, or if you're not allowed the right to be yourself online, this will not be possible. The community formed through internet is one built over a sense of common reality and openness, but from behind closed doors. That should be fine. But yeah, that's where I would like to end. If you right to anonymity directly relates to right to expression, it also relates to right to information. An infringement on this is a major threat to some of the fundamental rights. But thank you.
Thank you, Smita. Thank you very much. Well, everyone, I think you understand now why it's difficult to organize a merged workshop. Summarizing all of that is impossible. I'm not going to try, but what I am going to do is take a few minutes of the coffee break. We have 5 minutes left of our session. I'm going to let us run on to the coffee break for 5 or 10 minutes, and just to give you space to ask questions directly of the speakers, and hopefully clarify anything that needs clarifying. and maybe get some answers, and then for the rest of it, I think maybe you can exchange business cards and URLs and emails if you want to follow up any of these questions. Because that was a very, very vast array of subjects to which there are no answers or no easy answers. Okay, any questions then, please? Sir.
Hi, I'm Chester Song from IITCOE Hong Kong. I'm an independent consultant on information security and privacy. I used to work for the Privacy Commissioner's Office in Hong Kong. But I think personally, I quite agree with Monica's comment, suggestions, and I think I find it. I find the ECJ ruling kind of opened up more trouble than solution. Of course, I mean they have reason which I don't completely disagree, but I think it's I find it more and more in a way that these platforms have been given the authority or deciding on behalf of its users what content to be dispatched or prioritized. For example, I think I'm not sure how many of you follows the U.S. News closely, but about the Dallas shooting of the black man, in the car. The video was posted by his fiance or girlfriend on Facebook, and and that kind of triggered a series of riots and other incidents, which some say actually the reason of the video got so spread and so widely and fast was because the priority that Facebook has given to video files instead of text and images. So when a powerful platform like that determines what sort of contents to be displayed or to be accessed when searched, this has it gives a whole lot of a whole different effects to the outcome. And another comment I would like to make to Professor Park's presentation was it's interesting that I like his suggestion about the ownership of the information and coming to that, it reminded me of an interesting case which a widow.
Keep it short, though.
Yes, a widow in the U.S. Named Dina McClay made a claim of his husband's suicide notes posted on the internet based on copyrights, based on the IP rights. That because she, as the widow, she owns all his assets, including the intellectual properties of his husband. And the court of Virginia actually give her the basically lay down the order that she has the right to enforce. And successfully, she was able to remove from demand and removed that notes circulating on the internet from many sources, which I think is an interesting case relating to Professor Park's presentation.
Thank you. And, next question, sir.
Thank you. I'm Andrew from Vanuatu at the Regulator's Office. I just wanted to ask a question relating to anonymity. How does it balance off with abuse of the privilege of being anonymous? I ask that questions because we have an issue back home where we had a a large Facebook group of about 30,000 people in that group, and a lot of posts were very abusive, and even they're very abusive even to the government, and the government is not really happy with it, and I don't know how far away is the line and where is the balance in these situations like this. Thank you.
Could it be a case of freedom of expression and a democracy?
Yeah, but if the democracy is defaming somebody, then how do you address that?
Well, I think one of the panelists should answer that first. We have some lawyers on the panel. Would one of you like to answer that? The gentleman from Vanuatu? Can you? Yes.
I want to answer that because in our country, we filed a constitutional challenge against real name registration law that required everyone making a posting on a major website had to register his resident registration number and real name. And we got that struck down. The Constitutional Court said anonymous speech helps democracy because it allows people to overcome the hierarchy coming from gender, wealth, social status, and talk to one another as equals. So it allows, to quote the court, it allows people to build a substantive democracy, not just formal democracy, but substantive democracy by having equal dialogue. And the court also made a special mention that the internet is just about the only space this anonymous speech is possible. And to add to that, even without real name law, even without SIM card registration, even without this this preemptive laws, there can be laws through which the law enforcement can track down individuals abusing anonymity by trolling and other things. The law enforcement can get a warrant from the court, showing those bad postings to the court, and say that, and prove that there is a very high likelihood of crime being committed, and then the court will issue a warrant that authorizes unmasking of those individuals.
The right to anonymity is same as any other right, right? So if you use your right to infringe on someone else's right, or you violate someone else's right to dignified life, to life, or to even libel, then you lose your right. Then you have to face the repercussions of that. It's not like right to anonymity exists in a vacuum.
Now we have this gentleman here. Give us your name, please.
Hi, this is Moshe Sragana from Pakistan. By profession, I am a forensic investigator. So my question is quite similar. Anonymity is my right. Okay, I agree. What if I commit an online crime? What if I anonymously trap a young guy, and kidnap him or her and ask for some ransom? And what if I'm a terrorist? I'm doing online activities, I'm doing online recruitment. My government can't catch me, can't trace me because I'm anonymous. What do you think? There should be some limits. There should be some privilege to the government. They can do surveillance on me. They should be able to do it, I think.
Let me step in and as a comrade to my colleagues, although I think it was addressed to a different person perhaps, but can you kidnap anonymously? This is kind of a strange question actually, because I think most kidnappers try to do it anonymously, at least initially, or so it doesn't, we don't see how this digital space should be different from others. And as already was said, like it's not an unlimited right, yeah? So if you commit a crime, you definitely waive your rights. So it's true. Perhaps what was more interesting aspect of your comment was indeed if in the context of terrorism and so on. But I think that there is always means to surveil people. The question is how, what are the limits and where should we draw the line? So I'm sure that even if I comment anonymously on some daily newspaper's commentary section, I'm not totally anonymous, yeah? So there are ways to find me. Maybe not necessarily for everyone. So perhaps these are the boundaries that we're talking on. My identity shouldn't be open to everybody, and I'm sure had there been a need, it would be found. Thank you.
And when you say that the government should have the right to surveil, then who watches the government? Who looks at the limit which they put? There's a phrase which says, who watches who guards the guards, who watches the watchers. Like it's there.
Yeah, I would also respond to that the governments are surveilling people anyway, right? So it's not just one government. It's like if if NSA and GCHQ can surveil people across their borders, then I think we really need to have this debate of rights and ask for a right to anonymity. And I already said that this discussion hasn't been taken place in Pakistan.
Maybe the question is for respecting all the conventions on human rights which exist already, yes, and putting them into domestic legislation, because many of them are not ratified, or perhaps not ratified. If they're ratified, they're not actually translated into domestic legislation and in modern phraseology and actually with regulations to specify how they should be implemented. Sorry, lady.
Yeah, hi. I'm Maria Omar. I'm from Pakistan, from an organization called the Women's Digital League. I'm really stuck here because on the one hand, I do want my anonymity, my right to be anonymous and to say what I like, responsibly, of course. But I know that on the internet, maybe more so in my part of the world, if you're a woman and you're working for women and you're doing something out of the ordinary, which I guess being a woman working for women would be in Pakistan. But there a lot of people take advantage of their right to anonymity to troll you, and not criminally troll you, so one person just completely, bothering you all the time, but a group of people who are all in on it, coming and posting stuff on your Facebook page, on your organization's Facebook page, sending you DMs, sending you messages, and until it gets to the level where it will be seen as criminal by a law agency, where it's really going to hurt you physically, nothing will be done. What about the psychological trauma that it causes you? Someone like me working in that sphere where I am isolated, or I can be isolated very easily. What do I do then?
I would like to answer this. One, anonymity will help you here, and two, the internet is huge. The point of internet is that you can get allies, and your allies don't have to be in Pakistan. If the law enforcement agency is not taking you seriously, reach out to people on Twitter. Tell them this is happening to you. They will come to your support. If they have people who can troll us, we can troll them back. Just saying.
Thank you, Smita. Don't suggest two wrongs should ever make a right. Please. Any other questions, please? Comments? Yes, sir, at the back. Have you got a microphone? Also, we have to remember the case of children, underage children who get trolled on the internet.
I'm from Vietnam, and I just want to have a comment on the topic that if someone can kill you, and they can cover their face and come and kill you, so should we have a law that stop people cover their face when they go out the house? No, right? So it's the same here. Like someone can anonymously come and spam on you. You can have a war that stop anyone anonymously comment on the war. That is a technical solution. But I want to come back that anonymously is a right, and it's only can be stopped and get get out that people when they doing something criminal and harmful for the society. But we should not prevent people to have the right just because of a potential harmful, and that maybe some of them, just a little of them, can use us that thing to do harmful for people. Yeah.
Okay, thank you. I think that introduces many other subjects that we don't have time for here, and which might lead to heated debate, especially in countries with extensive migration. Any other quick questions? Very quick. One more. We have time for one more question before coffee break. Who wants the last question? Sir.
Thanks. I'm Atik from Thailand. Back to the rights to be forgotten and like issues on identity, privacy. I don't really have an answer or questions, but just some comments to share. That like one other thing I want people to explore more is about the temporality, like about the time as well. Park mentioned about relevance, right? And I think like when we're talking relevance, it's also about, I mean, in general, in the context is also about time as well. So when we're talking about, say, for example, things to remember, right? In the case of the presidential records, right, in the U.S. law, it is like it is like by law, right, that you have to record all the things that like the president say, or like send messages, whatever. But there's also limits that the access of those things that got remember, it's not immediately at that moment. The president should leave the office first before those records can be accessed. Okay. So how to actually like, I mean, I'm not sure whether like it's a right way to frame it in that sense or not, but like when we're talking about rights to be forgotten or privacy or access to information to protect people, also the anonymity as well, should the time frame also be in consideration as well. Say, okay, for example, when I'm online, I'm still alive, right? Maybe I don't know, like nobody should like getting into my records, whatever. But if I'm die today, maybe tomorrow people can access, okay, because it's
too big.
I don't know. Well,
that's too big a question to deal with now. Sorry. All right, I think we have to stop now because we will be thrown out. And anyway, it's time for your coffee break. But I know it would be good to continue for another 2 hours. Thank you very much for your close attention to all these questions, and apologies for the confusion at the beginning, but we did our best to put together an impossible squaring the circle type workshop. So once again, thank you for coming.